And Chrissy, I see another text up there. Go ahead and read that for us if you would.
Sure. So it's how to remove someone from the deed to the property. So I know that's a bit generic, but
Well, the bottom line is that if there are two or more people on a deed to a piece of property, the easiest way to do it is that by having their cooperation. So if
exactly.
A and B own the property together and B is agreeable, B would simply sign a deed where he removes his name from the property and puts the whole thing into A's name. We don't really know if there's a dispute here, but could you force B to sign over his interest in the property? Generally, the answer is no. But with cooperation, it can certainly be done. The cost of preparing a deed is not that much, but remember that in these deeds, there may be doc stamps due. You may have to pay the state of Florida documentary stamp tax for the transfer from one to another, even if there's no money's changing hands. That doc stamp is based on what the outstanding mortgage balance is.
Exactly. And if they don't agree, then they could do a suit for partition.
Yeah, so tell listeners about that.
If two or more owners of a property cannot agree on keeping the property or selling the property, if they are having some type of disagreement and they're not cooperating with each other, then one or more can file a suit for partition, and a suit for partition legal action is meant to prevent restraint from alienation. It is meant to prevent that you cannot have somebody tying up a piece of real estate, so it will force the sale of the property, and that is another option.
Chrissy, I was about to tell you about a call I got earlier this week. It was coming from Mom, and she was very concerned about Son. And Son had owned a home, and Son did something that, normally we might tell him not to do, but he was nice enough to add his girlfriend's name to the deed to his home.
Okay.
And I suppose you can imagine what's happened now.
I can.
So she's not his girlfriend anymore. And so she moves out, and he says, okay, I'll give you all the furniture and $5,000 if you'll give me your interest in my home back to me. And so she promptly takes his $5,000 in the furniture and leaves, but he didn't bother to get a deed signed. Now he's calling her and say, hey, will you sign a deed? And she's saying no. Guess what? There's about $30,000 equity in the property. I'd like another $10,000. So this is what the mom is telling me, of course. And, of course, Mom is thinking, well, it was his home and he made all the mortgage payments and, all these reasons why she shouldn't get another dime. And, can we sue her? And I go, you know what? You'd spend a lot more than $10,000 suing her and get an unknown. We don't know what the result of that would be.
Exactly.
So the bottom line is that he's going to have to pay up. $10,000 is a relatively cheap way out of this. And she goes, well, he doesn't have $10,000. He's going to refinance a home. Well, that's going to be $6,000 or $7,000 in refinance fees just to raise $10,000 to pay her.
He can't refinance without her signing.
She'd have to cooperate.
But what I'm saying is, how is that? Yeah.
Well, the way that happens is
meaning you're right. Is she would have to cooperate with that too.
She'd have to cooperate at the moment of closing on a new loan. At that moment, she would sign the deed, and she'd walk out of there with $10,000. But what's the lessons to be learned there for Son? Number one.
Yeah. Well, he obviously should not have done that in the first place.
Shouldn't have added her name to the deed in the first place.
Exactly.
Okay.
Yes.
And number two, striking a deal that she gets all the furniture and $5,000 for her interest in the property. Great. I'm happy for him. That was a great deal. But he should have gotten her to sign a deed first before that.
He did the exchange.
Exactly, yes. So, they're all very upset about it. Now, I'm sure they're going to hate paying her $10,000, but that is, at the end of the day, their least expensive way out of this deal. And if they said, we're just not going to do anything about it, well, then we get back to this suit for partition that you were talking about, where the girlfriend could come in and force the sale of the property and have the monies to pay all the costs of closing and pay off the mortgage. And then split whatever's left over at the end of the day. And that's not a great solution for them either.
Correct, exactly. At least there is a legal remedy. However, it's really a shame, when this happens. And obviously, we know that no one has a crystal ball and you don't foresee that going into that. But what you just described, Tom, I have had 7 phone calls and or meetings with people this year, the same thing. And so the word of caution is that it has to do with every one of these, which is exactly like yours. It's all where these young people purchased property together or added them on and they were not married.
Mm-hmm.
And it's okay. You can do that with anybody you want. However, now things went south and they're not together.
Right.
Just like yours, these other 7 people with me. And I've actually alerted our daughter Alexis, who will be coming, on board here soon as an attorney. I said, Alexis, I want you to be aware of something. I really brought it to her attention. I said, because this is a lot of people your age, young people that are doing this. And I said, I know they're going into it with the right intention. However, they really should think through the consequences of what happens if they do split up.
Yeah. In my 40 years of law practice, I'd say less than 5 times, I've done a written agreement between 2 people that would govern their relationship regarding this joint ownership of a piece of paper.
That could be the way to go.
And they were the ones that called me and said, Tom, we're boyfriend, we're girlfriend, we're going to buy a piece of property together. We'd like to have something in writing that defines what our relationship is going forward. And it's been a while since I looked at that agreement, but it's on the computer, but it did lay out what would happen.
So that's really great that you obviously already did this and were thinking ahead of your time, because of course you didn't have to deal with this much before. Fast forward to now, I think that it's going to be something that is more common. Of course, in your situation with the client, with the mom, and these 7 people that I spoke with, these were none in any of these. We did not prepare the original deed, of course. So we weren't involved in that process. Obviously, where you did an agreement, good for them. They were coming to you to ask you for advice before they did it.
Yeah.
So that's super.
Well, let's start with the basic, and that is this. Let's say we got a boyfriend and a girlfriend, or friends, whatever it happens to be, and they're buying a piece of property together, and they start out with the best of intentions, but we know things can go south. But I would say this: if they're putting in equal amounts of money, if let's say the down payment's $40,000 and they're both putting in $20,000, hey, that's a reason to put both their names on a deed.
Exactly.
If the woman is coming in with $40,000 and the man is coming in with $0, hey, you know what? That's a good reason to not put it in both names. It's a reason to put it into her name only. So, he's got to have skin on the game if he's going to put his name on a deed, in my opinion. Somebody's got to, break the news and set her straight, you might say.
Absolutely. And I think that, Tom, in each of these situations where I'm referring to, they both put in money, so.
Yeah.
But you're correct. It could be one or the other.